Hi, I'm Ed Jaeger, chair of the Subrogation group at White & Williams. Welcome to Subro Sessions. On today's episode, Gus Sara will discuss the malfunction theory of products liability. If you have any questions or suggestions for future topics, email us at www.info@whiteandwilliams.com.
Hello, everybody. Thanks again for joining us for another episode of White & Williams Subro Sessions. I am Gus Sara, Counsel in the Subrogation Department of White & Williams. And today we're going to be discussing the malfunction theory of products liability. I'm going to start by giving a brief overview of the concept, and then I will discuss a recent Pennsylvania Superior Court case that recently came up on appeal from Dauphin County Court of Common Pleas that addresses the malfunction theory and how Pennsylvania handles it and how they recognize the elements. The case in question is the Pennsylvania National Mutual Casualty Insurance Company versus Sam's East, Inc. We're going to start with just the definition of malfunction theory. It is essentially an alternative theory of products liability that permits a plaintiff to prove a product defect with circumstantial evidence of a malfunction, and it's a very important and with evidence eliminating abnormal use of the product and reasonable secondary causes of the event or loss. This definition is how it was articulated by the Pennsylvania Superior Court in Penn National versus Sam's East, Inc., but the exact definition can vary from state to state. Typically, the definition is always requiring that the plaintiff establish the circumstantial evidence of a malfunction and rule out all necessary causes. But there could be nuances in the types of causes. It could be rule out all possible causes, rule out all likely causes. In Pennsylvania, the plaintiff is required to rule out all reasonable secondary causes of the event. Some states even call it something different than malfunction theory. It could be indeterminate product failure theory and other types of definitions. And some states do not recognize it and require that you establish products liability through their primary doctrine that the courts or states have adopted. Pennsylvania has adopted strict products liability as set forth in 402A of the Second Restatement of Torts. That is the primary liability theory in Pennsylvania. And the elements required to establish strict products liability is that the product was defective, that the defect had caused the plaintiff's injury, and that the defect existed at the time that it left the hands of the manufacturer. And if you have a case where you can prove a defect and you can identify the defect, then obviously strict liability is the route that you want to go. It is a more reliable and effective theory of liability, and it's not as dependent on circumstantial evidence. If you have evidence of a component failure, such as an arc or some type of physical proof of a defect, then obviously strict products liability is the way you want to plead your case. However, as we all know, in subrogation, we deal with a lot of fires and catastrophic events where the product is severely damaged, and we do not have the physical evidence to prove an internal defect inside the product. In those circumstances, jurisdictions such as Pennsylvania provide this alternative theory, the malfunction theory, for those circumstances where the defect cannot be identified. This doctrine contemplates the reality that sometimes the evidence simply is too physically damaged, and you have to rely on other sources of evidence to establish your theory of liability. And that brings us to a recent case, Penn National Mutual Casualty Insurance versus Sam's East, Inc. This case is from 2021. The Superior Court released its decision on March 19th, 2021. And it involves a fire to the home of Gerald and Michelle Thompson. The fire occurred at around 4 a.m. on February 28th, 2015. Mr. Thompson and his son were asleep in the basement. They had a space heater operating near them for about 4 to 6 hours before Mr. Thompson was awoken to the smell of smoke and the sound of crackling. Upon discovery, he found a fire at the space heater. He immediately threw a cover over the space heater and tried to carry it out. This act of attempting to carry the space heater outside caused injuries to his hands and arms. His wife, Miss Thompson, and son unfortunately sustained smoke inhalation damages as well. And obviously, the home incurred significant fire damage as a result of the fire spreading to the entertainment center, the flooring, and the furniture in the basement. Penn National was the property insurance carrier for the Thompsons at the time of the fire. As such, they issued payments to the Thompsons for the property damage incurred. As typical, Penn National decided to hire a origin and cause fire investigator to investigate the fire to determine what caused it. The fire investigator, whom I've worked with personally on several cases and find to be an effective investigator, determined that the fire came or originated at the space heater. Unfortunately, all of the electrical components were either consumed or too severely damaged to pinpoint the actual cause of failure within the space heater. However, the origin and cause investigator was able to rule out all other possible causes of fire in the area of origin and came to the conclusion that the space heater had to be the cause of the fire. As such, in 2017, Penn National and the Thompsons filed a complaint against the store that sold the space heater, and that was the defendant Sam's East Incorporated. Due to the damage to the product itself, they were unable to identify the manufacturer, so they instituted an action against the company that sold it. The product was purchased in 2011 by the Thompsons' mother, who gave it to them as a gift in December of 2011. According to the Thompsons, the space heater operated without issue for several years. They used it approximately 20 hours a month during the winter months and had no required maintenance on it. Mr. Thompson claims that he read the user instructions, but never had any issues with it and never had to get any repairs on the space heater. The defendant, Sam's East, filed a motion for summary judgment on grounds that the cause and origin report was insufficient to satisfy the plaintiff's burden of proof because an actual product failure was not identified. The trial court granted the motion for summary judgment, agreeing with the defendants that plaintiffs simply did not have established enough evidence to meet its burden of proof, saying in quotes that the case was devoid of identification of a design defect, how any alleged defect caused the heater to catch fire, or identification of what type of safety design should have existed. The trial court also noted that the plaintiff could not avail itself to the product malfunction theory because the expert was actually able to examine the product. The plaintiffs then filed an appeal with the Superior Court. The court acknowledged that Pennsylvania's primary products doctrine available to plaintiffs is strict products liability, in which case a plaintiff would be required to identify a specific defect within the product. However, the court also acknowledged that in circumstances where the product is either totally consumed or partially consumed, plaintiffs have the ability to assert the malfunction theory, in which they can rely on circumstantial evidence that a malfunction occurred if they can also establish that the product was used properly and that there were no reasonable secondary causes of the fire. For the first time that I recall, the court clarified that even if you had portions of the product, or you were able to retain some amount of the product, some remnants of the product, you can still avail yourself to the malfunction theory. And this, I believe, was a critical point in the holding in this case, because the lower court tried to establish the precedent that if you have some remnants of the product, you are no longer able to assert the malfunction theory, because the expert in theory would be able to examine the product to try to find the failure. The Superior Court stated that that is not the case, and that even if you have the product to inspect, it's not always guaranteed that you're going to be able to identify the product failure. As such, the court reversed the dismissal or the summary judgment motion and remanded it back to trial court. This is a very important case for those practicing or asserting products liability in a subrogation case in Pennsylvania, because it allows the plaintiff to proceed even if they cannot pinpoint the physical cause of the failure or defect in the product, as long as the experts can rule out all other viable causes of the fire. And that's a big if. If there's structural wiring in the area, other products in the area, the experts will have to be able to opine that those items were able to be ruled out and are not viable ignition sources in the fire. So it's essentially like process of elimination, where there is circumstantial evidence that the product itself or the product in question failed. In this particular case, Mr. Thompson woke up and witnessed a fire right at the space heater. So that is circumstantial evidence that would be critical to proving a malfunction theory in this case. Another interesting point is that the fire investigator was the one that issued the report stating that a malfunction of the product caused the fire. Typically, we have mechanical engineers and or electrical engineers handle that part of the investigation and issue the reports regarding a defect in a product. But in this case, since the actual defect wasn't able to be identified, the court was okay with the fire investigator rendering the opinion that it had to be a malfunction, since he essentially used fire science to rule out all the other possible causes. So in a malfunction theory for products liability, it is possible that you can probably go through the case with your fire investigator as your primary expert without necessarily having an engineer. That being said, I think that having an engineer, even in this case, would be more effective in ruling out the structural wiring, the other products in the area. There was an entertainment center with a television there. And that is a uphill battle for a fire investigator to have to be able to opine that those products did not have electrical failures. Arguably outside the expertise of what a fire investigator can opine. And it's possible that in this case, the defendant can later on in the case move to strike the fire investigator from rendering opinions that require a more specialized expertise, such as an electrical engineering background or a mechanical background. So I found it interesting that in this case, the plaintiffs were relying, it appears, primarily on the fire report to support their malfunction theory. It's important for everybody handling subrogation cases to keep in mind the possibility of a malfunction theory and check that jurisdiction to see if, like Pennsylvania, there is an alternative theory, such as a malfunction or indeterminate product theory, as an alternative to a strict products liability in those circumstances where a product defect cannot be identified. Thank you very much for stopping by, and we'll see you next time.
Thanks for listening to Subro Sessions. On our next episode, we'll hear again from Matt Ferry, Gus Sara, and Leon Scaff as they walk through and debate 3 different hypothetical situations around the topic of spoliation.